Hi everyone, thanks for signing up for today's webinar. Just a bit about me first of all. My name is Helen Gardiner. I'm a barrister practising out of St Philip's Chambers in Leeds. I specialise in employment law as well as general commercial litigation, and I've been in the job for just over 7 years. I accept instructions on behalf of clients through solicitors, but I'm also licensed to act on a direct access basis, meaning I can accept instructions from clients direct. And you can find my contact details on the slides, which Liz is going to make available for download after the webinar. So if you have got any queries, feel free to get in touch. Today I'm going to talk to you about unfair dismissal. We've not got that long, so today is necessarily an overview of the topic. If you think it would be of help to have some more detailed webinars on certain issues, perhaps capability or misconduct dismissals, do let me know in the chat window and I'll be happy to talk to you again in the future. And if you've got any questions as we go along, raise them and I'll do my best to answer as we go. So unfortunately, dismissals for whatever reason are something that every employer will have to deal with at some stage. It's likely that if you have carried out any dismissals, you will also have faced a claim in the Employment Tribunal for unfair dismissal. It's far and away the most common kind of case which we see being decided in employment tribunals. And the aim of this webinar is to give you some pointers to reduce the likelihood of an adverse finding against employers if matters do get that far. So the current provisions regarding unfair dismissals are contained in the Employment Rights Act 1996. I've put an extract from that on the slide, which you can see now. That provides that the dismissal of a qualifying employee will be unfair unless the employer can show that the reason or the principal reason for the dismissal was a potentially fair reason, and there are 5 potentially as we'll see. And secondly, the tribunal finds that in all the circumstances, the employer acted reasonably in treating that reason as a sufficient reason for dismissal. So that means that the dismissal must be both procedurally and substantively fair. The ACAS Code of Practice on Disciplinary and Grievance Procedures applies to dismissals for misconduct or poor performance, and it must be taken into account by tribunals in deciding whether an employer has acted reasonably in relation to following a fair procedure and giving fair warnings prior to a dismissal. The code is essential reading for anybody involved in a dismissals process, and the code and the statutory guidance can be downloaded free of charge from the ACAS website. So I've put that link there on the slide. So first of all, who can claim unfair dismissal? The right to bring a claim is available only to an employee who has been dismissed and who, in most cases, has 2 years qualifying period of continuous service as at the effective date of the termination of their employment. If you're not sure whether an individual is an employee or whether they've got sufficient continuous service, for example, because they've left and they've been reinstated, or because they've been off sick for a substantial period, then do get in touch because those are legal points that I can assist you on. The qualifying period doesn't apply in most cases where the dismissal is for an automatically unfair reason, and there's no qualifying period required where the reason for the dismissal is or relates to the employee's political opinions or affiliation. Also, it's worth noting that if the employee is dismissed in circumstances where they would qualify for a paid suspension on medical grounds, then the qualifying period is reduced to just 1 month. Next question is, what is a dismissal? There are 3 categories of dismissal: termination by the employer being the most obvious, expiry of a fixed-term contract, and constructive dismissal, i.e. where an employee resigns in response to a breach of contract by the employer. A couple of other things to note. An employee who's been given notice of termination by the employer will still be treated as dismissed even if they bring their employment to an end on an earlier date by resigning during the notice period. And just one other thing to bear in mind, unilateral changes to employment terms which are imposed on an employee may constitute a termination and a re-engagement, so that could open up a claim for unfair dismissal. Looking then at the potentially fair reasons for dismissal, I've listed those on the screen in front of you. They are capability or qualifications, conduct, redundancy, breach of a statutory duty or restriction, and some other substantial reason. The reason for a dismissal can fall into more than one of those five potentially fair categories, and there's a certain degree of overlap between them. So it's important to refer to every potentially fair reason for dismissal when you're dealing with the dismissal, and then if you have to defend an unfair dismissal claim. We'll look at them each in a little more detail as we go along. If you've got any relevant experience of the matters I'm talking about, or like I said, if you've got any queries, do feel free to speak up and share as I'm talking away. So first up, capability. For the purposes of an unfair dismissal, capability should be assessed by reference to an employee's skill, aptitude, health, or any other physical or mental quality. The capability has to relate to the work that the employee was employed to do, but a dismissal can be fair even if the employee can still do part of their job. In practice, capability dismissals usually fall into two main groups. First, a dismissal because of an employee's poor performance, and secondly, dismissal because of an employee's ill health. Just a word of warning on that last point. Employers need to be aware that in the case of dismissal for ill health, if the illness amounts to a disability under the Equality Act 2010, then the dismissal may amount to unlawful disability discrimination under the Act, even if it's fair under the ERA. Now, obviously, discussion of disability discrimination is beyond the scope of this webinar because it's a whole topic in and of itself, but if it's something you need assistance with, then do feel free to get in touch. Next up is conduct. It's potentially fair to dismiss an employee for a reason that relates to the conduct of the employee. It can be either a single act of serious misconduct, or gross misconduct as it's termed, or a series of acts that are less serious. So, for example, it could include misconduct such as disobeying reasonable orders, theft or dishonesty, unauthorised absence, violence at work, things like that. These are just examples, and the list could go on and on. Most employers will include examples of unacceptable misconduct in their employment contracts or their staff handbooks. If your company does so, ensure that it's made clear that any examples aren't exhaustive. Otherwise, you may find yourself in a situation where you want to discipline for an act of misconduct which is apparent, or it's obvious to anyone, but which isn't included, and it could give scope for an employee to argue that the conduct wasn't to be deemed to be misconduct, or alternatively, it wasn't reasonable to dismiss for a reason not listed. Also, just because conduct is listed as gross misconduct within the staff handbook doesn't mean that such conduct will always amount to gross misconduct in fact. So what I'm saying is, don't take a prescriptive approach. Ask yourself whether it would be reasonable to consider the conduct in question to be gross misconduct. Last point on the slide, sometimes it will be fair to dismiss an employee for conduct outside of the workplace, so long as in some respect or other it affects the employee or could be thought to affect the employee when he's doing his work. But be careful about that, those kind of cases are rare. So to establish that dismissal was on the grounds of conduct, it must be established that at the time of the dismissal, the employer believed that the employee to be guilty of misconduct, and at the time of the dismissal, the employer had reasonable grounds for believing that the employee was guilty of that misconduct. That point goes to the question of reasonableness that we'll come on to later. Finally, the third requirement is that at the time the employer formed the belief on those grounds, it had carried out as much investigation as was reasonable in the circumstances. Next up is redundancy. A dismissal on the grounds that the employee was redundant is potentially fair. This applies where the dismissal is wholly or mainly attributable to one of the three things that I've listed. So that's the employer ceasing or intending to cease to carry on the business for the purposes of which the employee was employed, the employer ceasing or intending to cease to carry on that business in the place where the employee was employed, or finally, the employer having a reduced requirement for employees to carry out work of a particular kind or to carry out work of a particular kind at that particular place. Again, redundancy is a topic in and of itself. Generally speaking, what's required of employers to deal with matters fairly is that they put employees on notice that their role is at risk of redundancy. They should then consult with employees in relation to that redundancy situation and then make a genuine attempt to find suitable alternative roles for the employee. Make sure you don't think in terms of which individuals you wish to make redundant, and be careful how you decide on the pools from which redundancies will be selected. Final pointer here, where there are mass redundancies going on, anything over 20, be sure to comply with the statutory requirements for consultation with staff representatives and or unions. Statutory restriction I can deal with fairly quickly. A dismissal is potentially fair if the employee couldn't continue to work in the position which he held without either the employer or the employee contravening a duty or restriction imposed by or under legislation. And what the employer has to be clear on here is that continued employment would actually contravene a statutory restriction. I've put some examples up for you, and most common ones are that continued employment would breach immigration laws, or the employee has lost their driving licence and they need to drive to do the job, or because they've failed to obtain the necessary vocational qualifications which are required for their role. Next up, final potentially fair reason is some other substantial reason. It's commonly denoted as SOSR. The final reason is essentially a catch-all. It's presumably designed to catch potentially fair dismissals that wouldn't fall into any of the other categories that we've just looked at. It should be noted that following the abolition of the default retirement age, which happened in April 2011, dismissals of employees because of age where the employer can justify that retirement age, that's likely to fall into some other substantial reason for dismissal. In order to show some other substantial reason, it's only necessary to establish a reason for the dismissal which is of a kind that could justify dismissal of an employee holding the job in question. You don't need to show that it actually did justify the dismissal. It sounds a bit odd, but the distinction is important because once the employer shows it had a potentially fair reason, the tribunal then looks at whether the employer followed a fair procedure and whether the decision to dismiss for that reason was within the range of reasonable responses. So deciding whether the dismissal was justified isn't part of the test. Moving on to the... Oh, sorry.
Just after that as we're on it at the moment.
Do you need to still have a hearing to then dismiss by SOSR, i.e. follow the ACAS process? That's the question we've got. And this is something which I've touched on further down the line in this webinar, but I'll jump straight to it now. The ACAS Code doesn't explicitly include some other substantial reason. It only relates to conduct and capability procedures. But there has been a case in the Employment Appeals Tribunal which says that just because the ACAS Code doesn't say it doesn't apply to SOSR, then it can do. So I think in terms of SOSR, look at the ACAS Code as best practice and follow, if in doubt, follow it, essentially. So I would recommend that you do have a hearing just so that you make sure that an employee knows what's expected of them and you give them an opportunity to answer the matters which are put forward to them by the employer. I hope that helps. We'll come on to that in a bit more detail, and there'll be a slide on that then. It says, safer to hold a hearing then, thank you. Yeah, no problem. What would you call it? It wouldn't necessarily be a disciplinary hearing. Perhaps well, it depends on the circumstances. Perhaps, you've put me on the spot there. Yeah, we'll have a think about that. I'll come back to you on that. It's going to be fact specific, so something perhaps a meeting to discuss this particular issue and then invite them, let them know in more detail what the issue is. Just be fairly factually descriptive of what's going on is what I would recommend. So yeah, moving on to the fairness test. This all comes down to section 98.4 of the Employment Rights Act. We've already touched on it briefly. It says that the determination of the question whether the dismissal is fair or unfair depends on whether in the circumstances, including the size and administrative resources of the employer's undertaking, the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing the employee and shall be determined in accordance with the equity and the substantial merits of the case. The question of fairness is usually divided into two elements. First, whether the dismissal was procedurally fair, and secondly, whether it was substantively fair. The ACAS Code can be relevant when you're looking at both aspects of those, procedural and substantive fairness. Finally, if you've ever dealt with an unfair dismissal at an employment tribunal, you'll almost certainly have heard of a case called Polkie and Reduction. That comes from a landmark case called Polkie versus AE Dayton Services Limited. That case establishes two principles. Where a dismissal is procedurally unfair, an employer can't say, well, the procedural unfairness made no difference, and then try and argue that that makes the dismissal fair. So a procedurally unfair dismissal will always be an unfair dismissal. However, if a tribunal finds that the dismissal was unfair because of the procedural failing, but it was otherwise fair, the tribunal should reduce the amount of compensation to reflect the chance that there would have been a fair dismissal if the dismissal hadn't been procedurally unfair. Fairly circular argument, but hopefully you see what I mean. Although the details of the procedure to be followed will depend on the reason why the employer is considering dismissal, there are some principles of procedural fairness which would apply in both cases. So on the left-hand side, I've set those out. The employee should know that they're at risk of dismissal and why. They should be allowed to make representations, usually at a meeting or a hearing. And in some cases, they should also be allowed a right of appeal. The ACAS Code is more detailed. It applies to disciplinary situations, which explicitly includes misconduct and poor performance dismissals. It explicitly excludes dismissals on the grounds of redundancy or on the non-renewal of a fixed-term contract. But as I've just said, the Code is silent on whether it applies to dismissals for reasons other than misconduct or poor performance, such as dismissals on grounds of capability due to sickness. So, like I've already said, if in doubt, follow the steps set out in the Code. The Code is supplemented by a non-statutory guide called Discipline and Grievances at Work, the ACAS Guide. That gives further guidance on best practice, and again you can download that from the ACAS website. It doesn't have to be taken into account by tribunals, unlike the Code, which does, but it contains some useful guidance developed from some unfair dismissal case law, so don't ignore it, it's a useful resource. According to the ACAS Code, before dismissing for misconduct or poor performance, an employer should investigate the issues. Now that can include holding an investigatory meeting with the employee in question, as well as with witnesses to the relevant conduct, but it's not absolutely essential, it depends on the facts of the case. The employer should then inform the employee of the issues in writing, conduct a disciplinary hearing or a meeting with the employee, and inform the employee of the decision in writing. In addition, the ACAS Code provides that the employee has a right of appeal. The ACAS Code recommends two particular steps in the context of conducting the hearing itself. First, employers should at the start of the hearing explain the complaint against the employee and go through the evidence that's been gathered. And then secondly, employees should be given a reasonable opportunity to ask questions, present evidence and call relevant witnesses. And in certain circumstances, it will be appropriate for an employee who is accused of something to be able to cross-examine witnesses in the hearing. The substantive fairness, the test as to whether the employer acted reasonably in section 98.4, which I put up a couple of slides ago, that's an objective one. The tribunal has to decide whether the employer's decision to dismiss the employee fell within the range of reasonable responses that a reasonable employer in those circumstances and in that business might have adopted. So for the purposes of this test, it's completely irrelevant whether or not the tribunal would have dismissed the employee if it had been in the employer's shoes. The tribunal shouldn't substitute its view for that of the employer, and if it does, if it falls into that trap, then a decision can be appealed. The test applies both to the decision to dismiss and to the investigation which led to that decision. So that means that the issue for the tribunal isn't whether it would have investigated things differently, but whether the investigation was within the range of investigations that a reasonable employer would have carried out. So when you're thinking about the reasonableness of the reasonable aspects of the test that the tribunal is going to put forward, make sure that if you're carrying out the disciplinary process, if you're carrying out the dismissal, take a step back. It's quite easy to get bogged down in what you're dealing with. Take a step back and think, would an objective person looking at this think that I'm doing what's reasonable, or should I go back and ask another question of that witness? Should I go back and change the allegations and then do a further investigation? Just think about it objectively rather than just following procedure blindly. In deciding if the employer acted reasonably, the tribunal can only take into account facts known to the employer at the time of dismissal, and that means the facts known to the decision maker, not the knowledge of all the facts known to all the employees. Case law has set out what's required in terms of reasonableness when dismissing for conduct, redundancy and capability. We've already looked at the three requirements in conduct dismissals. That's the genuine, reasonable belief based on reasonable investigation, and the requirement in a redundancy situation. When deciding if the employee has acted reasonably in dismissing an employee for lack of capability, which would include ill health or qualifications, the tribunal needs to consider factors such as those that I've listed there. Whether the employee knew what was required of them, whether the employer took steps to minimise the risk of poor performance, whether there's a proper appraisal of the employee and the problem was identified, whether the employer provided training, supervision and encouragement, whether they warned the employee of the consequences of failing to improve, whether they were given a chance to improve, and in some cases, whether the employer considered alternative employment. That all sounds like pretty much common sense. You can't expect employees to be psychic. You need to set out what's expected of them, and you need to give them the opportunity of reaching that standard. Although, of course, that opportunity doesn't need to be open-ended. In most cases, a single act of poor performance won't warrant dismissal, and an employer will need to address the issues with an employee as part of a fair procedure. However, there are certain jobs that a single mistake could lead to major consequences and may warrant dismissal. So in mind, I've got pilots, nuclear scientists, train drivers, things like that. Deciding if a dismissal for some other substantial reason is fair will involve the tribunal deciding if the decision to dismiss falls within the range of reasonable responses. That's going to depend on the circumstances of the case. There's just so many possibilities. It's quite difficult to give you any general guidance on that, but it could involve an employer investigating the situation, consulting with the employee, warning the employee of the risk of dismissal, giving them an opportunity to state their case, exploring alternatives to dismissal, for example, verbal warnings, written warnings, final written warnings, and balancing the needs of the employer and the employee. One thing which will be a factor, which I haven't included in any of my slides, but it's just occurred to me, so I thought I'd best tell you, is that when a tribunal is looking at reasonableness, they're going to look at parity of treatment. So if you've got two employees charged or accused of the same two acts of misconduct, for example, and you dismiss one, but you only give a warning to the other one when all other things are equal, they've got the same disciplinary record, for example, that's going to be unfair. You need to treat everybody the same, unless you've got good reason not to. So bear that in mind. So far, we've already looked at potentially fair reasons. There are some specific matters which are automatically unfair reasons for dismissal, so you can never justify them. Given the time, I'm not going to go through them in detail. They're listed on the screen there, and you will get the slides through, of course. But generally, they refer to cases of industrial action. So they're, in this day and age, they're not hugely relevant, although they could be, of course. The procedure for bringing an unfair dismissal claim. Employees who believe that they've been unfairly dismissed have to first contact ACAS to see if the complaint can be settled through the ACAS early conciliation process. This is a fairly new system. It's only come in this year, and you have in terms of unfair dismissal, employees have to engage with the process. They cannot apply to the tribunal without their certificate from ACAS Early Conciliation, and if they try to, then the first response that you would give as employer is that the tribunal simply doesn't have jurisdiction to deal with the claim. If the case isn't settled through early conciliation, the employee's got 3 months minus 1 day from the effective date of termination to bring a claim. The clock is stopped for the period of early conciliation, so limitation is extended for the time spent in early conciliation. And just so you know, if the conciliation process ends within a month of the limitation expiring, limitations further extended to a month from the date on the EC certificate. If a claim is out of time, make sure you raise the point with the tribunal, because the tribunal is extremely unlikely to bend the rules unless there is a very good reason for them to do so, and they aren't that keen on doing it. We've just got a comment up here. We've had an employee go through ACAS via solicitor because clock was ticking on their date of dismissal. We have not dismissed. That's odd. If you've not dismissed, then there's no claim for unfair dismissal. Yeah, I'd be very puzzled as well. I'm not surprised that ACAS are. ACAS applies to quite a lot of different cases, so it may be that you've got some kind of discrimination aspect in there. You have to go through ACAS for discrimination cases as well, and of course an employee can discriminate without dismissing. I'm not saying that's what's happened, it's just that's a possibility. But yeah, if you've not, if you haven't already dismissed, then the clock doesn't start to run for limitation purposes. Once you get to the tribunal, obviously you've got all the opportunity in the world to settle without ACAS's assistance or with them. But if you don't, you get to the hearing. I know you're going to be having a seminar in a few weeks' time about defending a claim. Just be aware that the remedies aren't just compensation. An employee is entitled to ask for reinstatement, so they can be given their old job back, re-engagement, so they'd be re-employed by you but in a different role, or compensation. Realistically, everybody talks about compensation, everybody claims compensation. Very few people want to go back into the workplace once the relationship's broken down, but beware, that can be ordered. So that's basically my whistle-stop tour of the law of unfair dismissal. Thanks very much for listening. As I said earlier, do let me know if there are any elements of the talk you'd like a standalone webinar on. Some of them, like I've already said, can be topics in and of themselves. But in the meantime, feel free to pose any questions. There's one there about a future topic. Could you maybe cover protected conversations without prejudice in a future webinar? Yeah, I think that's a really good thing to look at, because without prejudice, you need to know what's covered, what's not, and what a tribunal can have regard to if you get as far as a tribunal. So yeah, we can certainly look into doing one of those. Next question, would ACAS consider applications which do not have sufficient length of service for unfair dismissal claims? They shouldn't do, but in my experience, they do. They just accept the applications. It's usually the first thing that, certainly if you get a lawyer involved, it's the first thing that look at is the qualifying service, and it's the easiest way of getting a claim knocked out if it's not already out of time. You would simply ask for it to be dealt with summarily by the tribunal. ACAS, it's not, a hugely personalised service from my experience of it. They get claimant after claimant coming through, and they assign it a certificate number and off they go. So you may get some that slip through the net. Don't necessarily be alarmed if you do. Just because ACAS considered the claim doesn't mean that it automatically means it's going to get as far as a tribunal hearing. So just bear that in mind. Any other questions?
Yeah, we've got, hang on, quite a few people. Do you have to enter into conciliation?
In terms, well, this is probably a talk in and of itself. you can't unreasonably refuse to conciliate, but conciliation is more about opening the avenues for talking between an employee and an employer. It can be a long process if you're close to reaching an agreement. Equally, it can be an extremely short process. So if it's clear that whatever happens, the employee wants to go to tribunal, have their day in court, as many of them do, then it's going to be a short process. Just make sure you respond to the communications from ACAS. Don't say, I'm not interested. Um, and the um, sorry, I'm reading ahead before I'm reading ahead before I answer the question. Um, I've lost where I'm up to. I'm sorry.
Conciliation time.
Conciliation, yeah. So engage as you can. You don't have to, go to extraordinary lengths if the employee isn't cooperating, but be reasonable in your responses. Next up, if notice is paid in lieu, how do you calculate the 90 days for bringing a claim? Okay, interesting question, crops up a lot. If you pay notice and they are on garden leave, then the effective date of termination is the last day of the garden leave. But if you pay in lieu of notice, then the effective date of termination is the day that they are dismissed, and the time begins to run from that date. So hopefully that answers that one fairly swiftly. Another question. We dismissed an employee due to ill health capability and she appealed. At the end of appeal, she wanted her job back even though we did not uphold her appeal. We are not going to give her job back. Are we being unreasonable? If you have dismissed and she's gone through the full process in terms of your processes as a business, i.e. the hearing and then the appeal, and you've not upheld her appeal, then no, you don't need to give her her job back. Without a bit more information, it's difficult to say whether you're being unreasonable, but as long as you've engaged in good faith in the process, then you're probably fine. Oh, it's a busy one, this one. Dismissal and illness, how far should you go with making reasonable adjustments before dismissal? Ooh, that's more of a disability topic than anything else. But if somebody is ill, that you are under a duty to make reasonable adjustments in the workplace if they are deemed to be disabled within the meaning of the Equality Act. I'm not going to go into that because that's going to take forever. If they are deemed to be disabled, you'll get assistance with that. Yeah, apparently we've got a disability webinar that can be sent through, so that might help. But usually occupational health will have got involved by that stage. You don't need to make every adjustment which is possibly available under the sun. You only need to make reasonable adjustments. So that might be not taking into account disability-related absence as part of the overall absence procedure. It might be allowing reasonable time off for medical appointments, or it might be things like providing a different kind of chair, something like that in the workplace. You only need to go as far as is reasonable. That can involve you having to spend money in order to do it. It can involve you treating that particular employee more favourably than you would treat a non-disabled employee. But you don't have to give the earth. Again, it's all fact dependent. I mean, feel free if you want to, if you've got a specific set of facts in mind, feel free to drop me an email and we can have a chat about it. My email address is going to be on the screen in a moment. In fact, I think we can put it up now. And yeah, there you go. There's my contact details. So feel free to drop me a line. So you can still dismiss, even if the individual has a disability, still need to be able to do the job. Yeah, that's absolutely right. Because somebody is disabled, it doesn't mean that they have a free path to employment. But you can't dismiss them unless you've got reasonable, well, I think the answer to this is listen to the disability seminar, because this is it's a whole topic in and of itself, and it's a complicated one. So I don't want to give you just some fleeting advice that sends you off down the garden path, landing you with a claim in your lap. That wouldn't be ideal. Is there anything? I know this is it's been, like I say, a whistle-stop tour, but if you've got anything else that you want to ask, shout now or, yeah, drop me a line. That would be great.
Okay, the total still time.
Oh, some still typing, yeah.
Let's see what's coming through. Okay, got a couple of minutes. About there. Okay.
It sounds like we're all winding down. Thanks very much for listening. It's been great chatting to you, and I'll hand back over to Liz.
Wow, thank you, Helen. That's a lot going on there, wasn't there? Brilliant. As I said, I will put as many links as I can to the recordings that might be relevant for this one as well in the slides that I send over to you. So thank you ever so much. And please get in touch with Helen. I'll put her details again on that email to you if you do have any questions. We are running the webinar, How to Defend Yourself in an Employment Tribunal, which the link will come up at the end of this webinar. And that's by Marie Walsh. It's a rerun, actually, but it's a very popular and a very interesting webinar. So we go hand in hand with this particular one. Next week, another popular one, Managing Through the Winter Months. In fact, this is almost up to full subscription levels. So please join us on that if you do have the opportunity. The link is there for you all to see on your slides. And finally, thank you ever so much, everybody, for making this a really engaging and enjoyable webinar today. Please get in touch if you've got any ideas. There's a lot that have come out of today with regards to some possible opportunities of further webinars for Helen next year. Some of you I've spoken to as well. I am sort of trying to do the rounds and having a quick conversation with everyone just to get some feedback when I'm doing my strategy for next year's webinar. So really appreciate your time. If you just give me a few ideas on what you think. Alternatively, get in touch with them any other way, and we're just almost bang on time there, nearly 1:45. So thank you everybody again, and we'll shortly end the webinar. Thank you.